Hello, my name is Joanne Gonzalez, and I'm a staff attorney with the Home Preservation Project of Legal Aid of Northwest Texas.
Hi, I'm Farva Raza. I'm the supervising attorney with the Home Preservation Project and Legal Aid of Northwest Texas. Today, we're going to be talking to you about understanding basic rights and the basics of lockouts.
A lockout happens when a landlord changes the locks on a rental unit to prevent the tenant from entering. It is not an eviction. As many of you may be aware, landlords can lock out a tenant for non-payment of rent, but only temporarily and under very specific conditions. A landlord can only temporarily lock a tenant out of the rental when the lease includes notice of the landlord's right to change the locks, the tenant is late paying at least part of their rent, the landlord gives the tenant advance written notice that the locks are going to be changed, no one is at home, they have not already changed the locks during this rental payment period, and the landlord gives the tenant written notice containing a number they can call at any time to have a key delivered whether or not they have paid rent.
A lockout should only occur in three situations. One, you owe rent. Two, your landlord needs to do repairs or construction, or there is an emergency. And three, you abandoned the property. Sometimes a landlord will remove an important item from the rental, like a door or doorknob, to try and get the tenant to pay rent or move out. Under Texas law, a landlord may not remove any of the following items from the rental unless they're fixing or replacing it. This includes door, window, attic hatchway, a lock, latch, hinge pin, doorknob, or other mechanism connected to a door, window, or attic hatchway. Any of the following items supplied by the landlord: furniture, fixtures, appliances.
Your landlord must give you notice before changing your locks. They can either mail out a notice at least 5 days before changing your locks, hand deliver the notice, or post the notice inside your front door at least 3 days before changing the locks. The notice must state in bold or underlined print that you have the right to receive a key to the new lock at any hour, regardless of whether you pay the rent you owe. The notice must state the earliest date the landlord proposes to change the locks, the amount of rent you must pay to stop the landlord from changing the locks, and the name and street address of the individual to whom, or the location of the on-site management office where the rent may be discussed or paid during the landlord's normal business hours.
Your landlord must also give you notice after the locks are changed. This notice must state the following: an on-site location where you can go 24 hours a day to obtain the new key, or a telephone number that is answered 24 hours a day that you may call to have a key delivered within 2 hours after calling the number. The fact that the landlord must provide the new key to the tenant at any hour, regardless of whether you pay any of the delinquent rent and the amount of the rent and other charges for which you are delinquent. Keep in mind that the landlord must give you a new set of keys even if you have not paid off your balance.
A landlord cannot change the locks when you or your family are inside the property. If you live in a residential apartment complex, the landlord is not allowed to prevent you from entering common areas, like a pool or community area. If your landlord refuses to give you a key or allow you back into the property, you can request an order from a Justice of Peace court allowing you to get back into the property. That order is called a writ of reentry, and you must file it with the Justice of Peace court in the precinct where the property is located. Once you file it, you will state the facts of an unlawful lockout under oath to the judge. If the judge reasonably believes that your landlord unlawfully locked you out of your property, the judge can issue a writ of reentry, a piece of paper that orders you to get immediate access to your property. That writ of reentry is served on the landlord by the sheriff or constable, and they may use reasonable force to enforce the writ. The landlord can request a hearing on the lockout within 8 days after you gain reentry. The hearing will be held within a week after the landlord requests the hearing. Check your mail, email, and voicemail to find out if there is a hearing so you don't miss it.
If a landlord violates any of the requirements of Section 92.0081 of the Property Code about lockouts, the tenant has the right to do a couple of things. One, to either file a request for reentry or a request to terminate the lease with the Justice Court. Two, to sue the landlord for a civil penalty for breaking the law. The court could require the landlord to pay the tenant 1 month's rent, 1,000, court costs, damages, and attorney's fees. However, keep in mind that the landlord can evict you even if the landlord illegally locked you out for owing rent. We hope this information has been helpful. If you're interested in our services, please call our office at 855-548-8457. Thank you for watching this video.